Good morning, everyone. I am pleased to be here. My name is Stephen Zolf. I'm a partner with Airden Burles, and I'm joined here by Angela Swan, counsel at Airden Burles, and we're here to discuss the topic of Canadians doing business in Cuba and the implications under the Helms-Burton Act. So we have a fair bit to cover today, as you can see from our overview. In a nutshell, recent developments relating to Helms-Burton Act are going to be of interest to many Canadian companies with any business interests in Cuba. And so we're going to start today with a brief survey of the landscape and recent developments relating to what is known as Title III of Helms-Burton Act. Now, as we'll get into today, this morning, in our view, the changes to Helms-Burton are likely going to bring renewed focus to Canadian blocking legislation, which is known in Canada as the Foreign Extraterritorial Measures Act of 1985, commonly referred to as FEMA. So just by way of quick background, the Helms-Burton Act was initially enacted in 1996 as the Cuban Liberty and Democratic Solidarity, or the LIBERTAD Act of 1996. But to understand Helms-Burton, you have to see it in the context of the long-standing U.S. economic embargo against Cuba since the revolution in 1959. Shortly after that, in 1963, the Cuban Assets Control Regs, also known as the CACRs, were enacted by the U.S. government to prohibit individuals subject to U.S. jurisdiction from doing any business, trading, etc., traveling to Cuba, and that became the long-standing economic embargo. Now, as many might recall, in the Obama administration, skip ahead, they had eased the CACR restrictions, but of course that dramatically reversed when with the Trump administration, which introduced its new quote-unquote Cuba policy. And about 2 years ago, in June of 17, restrictions were effectively reimposed. And of course, that brings us to Helms-Burton Act, because the key about Helms-Burton is there is a right of action, essentially, to U.S. nationals who owned property in Cuba that was confiscated on or after January 1st, 1959. And that act, under Title III, allows a U.S. national to bring civil suit in U.S. federal court. Now, what's interesting is, at the same time, Title III authorizes the U.S. president to suspend that right of action for sequential periods of up to 6 months. And in fact, every president through the Secretary of State, since the act was enacted by the Clinton administration, has issued sequential 6-month suspensions of that right of action. Now, of course, as we said, that changed with the onset of the Trump administration, and as you can see from the slide, just the chronology, ultimately ending up with an announcement by Secretary of State Pompeo that they would no longer suspend the right of action. Therefore, the Title III civil right of actions are deemed to go into force, in full force in effect, and that's happened as of May 2nd of this year, just a few weeks ago, not 4 weeks ago. So now that Title III is in force, we have to understand its broad application, and that in the statute itself, there are some very expansive definitions of trafficking and of confiscated property, which we've set out in the slide. Now, although we note, though, that trafficking must be knowing and intentional under the Act, but nevertheless, as you can see from the slide, it's a very, very broad basket of what can constitute trafficking and confiscated property.
Just to note one thing, it's not just using the property, like, as for example, a mine might use the property that was in Cuba, but it's airlines and cruise ships have been in the crosshairs because they've been using facilities. In the case of airlines, obviously, the Cuban airports. In the case of cruise lines, docks and piers. And so that's why it is so very broad. It's not obviously a target like Sherritt, but also Air Canada. And if you look at a larger list of things, a lot of the airlines in the EU are also being targeted. In fact, the first action that was started was an action brought against Carnival Cruise Lines.
Right.
So that's breadth of trafficking is simply you use the property.
Right, and so Angela, it's so broad that it could capture even that tangential or that nexus is sufficient. Yeah. Very interesting. So,
and so it's quite frighteningly broad.
I see. Now, just again by way of background, claims that are certified by the FCSC create a rebuttable presumption that the claimant's claim for ownership of property and its valuation, including a right to treble damages, will be effectively accepted by the court. And we have set out there the statistics. The government, starting in, I think, in the early 60s, while Title III was in abeyance, certified almost 6,000 confiscated property claims worth approximately $8 billion. Now, of course, keep in mind that $8 billion is the low end when we think about treble damages. It could be a lot higher. Plus, there have been estimates out there that there's an additional 200,000 claims outside of the certification process which might be pursued. And we've set out just a very quick list of the very high-profile actions that have already been commenced in the federal court since May 2nd, one of which is Exxon, and then as Angela.
And again, you just keep in mind that Exxon's suit goes back to 1960, and so interest on that amount for almost 60 years is going to have increased it, 4 or 5 times.
Right.
So the interest claims alone would be a staggering amount.
Oh my goodness, prejudgment interest for the last 50-odd years.
50, 60 years.
Right, right. So just a massive claim. So you can imagine scaling up that estimated valuations to date. So immediately following the suspension announced last month, Canada weighed in, along with other jurisdictions internationally, and very quickly there's been repeated castigation, if you will, of the decision by the U.S. administration to no longer suspend Title III. In particular, Canada issued a joint announcement with the EU, which we've quoted here, but what's very interesting is there's express references in those public statements by the Canadian government to FEMA and the blocking legislation which is in place. And that, as we're going to get into this morning, raises some key hurdles to Title III claims against Canadian and EU entities in their respective jurisdictions. Of course, we're going to focus on the Canadian side. Now, the blocking legislation, so let's get into the meat of this, Angela. The FEMA, we've set out here the key provisions of FEMA, and this is where things get interesting. These developments clearly with Title III are going to bring in this blocking legislation into some renewed focus, I would think. And what we've explained is that FEMA is essentially a blocking or a clawback statute. It prevents the enforcement in Canada of a U.S. judgment, and if the judgment even is satisfied in the U.S. because the judgment debtor has assets in that jurisdiction, FEMA is sufficiently broad to enable the Attorney General of Canada by order to authorize a clawback action in Canada.
How this would work would be, take Air Canada, for example. I don't know whether Air Canada owns its planes or leases them, but if Air Canada owns the planes that it flies into the U.S., a judgment from a U.S. federal court could lead to the seizure of an Air Canada plane at some U.S. airport, and then that would be the enforcement of the FEMA. The problem with that, of course, is that the people who are claiming, the claimants under Title III are ex-Cuban, residents, so that the chance of having an effective claim against them in Canada in the clawback statute is very small.
Right.
Talk in a moment about some of the history in which the situation was quite different, but FEMA has these two parts to it: the blocking, prevent the enforcement, And the other part of the blocking, which Steve has mentioned, is that it prevents the provision of evidence in American courts.
Right.
So there's two parts to blocking the award, blocking enforcement of the judgment in Canada, blocking the provision of evidence in Canada, and then the clawback. How effective the clawback is, and particular aspects of Title III, is a much more difficult question than in the earlier cases where it was first introduced.
I see. Now, thank you, Angela. And you mentioned that, we're going to get into that history, and I think it's going to be helpful, we hope, for our listeners to understand the context of blocking statutes in the context of Canadian law, because that will give some very, very, we hope, helpful context.
Yeah, the interesting thing is blocking statutes have been around for a long time. In fact, the Ontario Business Records Protection Act is still in force. In Section 1 there, you can see, prevents the disclosure of information of a business record outside Ontario. It was first enacted in 1947. It's been repeated in all the consolidations, revised statutes up until 1990, and it's still, if you go onto the E-Laws website, it's still there. Quebec had the same blocking statute. I don't know how long it's been there. I imagine it's been at least as long as the Ontario one. But the interesting thing was that in a case called Hunt and TNN PLC, the Supreme Court held that the application of the Quebec statute in litigation in British Columbia was unconstitutional. This case followed on from the very important decision in Morgard, which essentially introduced what I call constitutional constraints on the enforcement of, on the taking of jurisdiction and enforcement of foreign judgments. Morgard introduced in Canada something that looks very much like, and again, the American position of full faith and credit being entailed by acknowledgement of due process. And so a properly restrained jurisdiction will then entail the enforcement of the resulting judgment. Morgard completely transformed the law in Canada on the enforcement of judgments, and it's been developed extensively since then. And so Hunt and TNN was in that pattern in which the court is saying, no, Quebec cannot prevent the introduction of evidence in the BC statute, BC litigation, because the statute is unconstitutional.
Right.
The interesting thing, as you see, the last part of the thing there is given this finding is unnecessary to consider whether the Act is wholly unconstitutional because in pith and substance it relates to a matter outside the province. Nor is it necessary to consider whether the statute could properly be read down to permit its application to jurisdictions outside the country to consider the public policy issue raised. So the blocking statute might be available, Ontario one, provincial one, litigation outside Ontario. The problem there would be that the U.S. court issues letters rogatory, perhaps, or as a witness on the stand, and the consequence, of course, might be the default judgment, in which case your victory is kind of pyrrhic as opposed to real.
But Angela, from that quote we put up there, from that lengthy quote from the Hunt decision, is it right to say that we could maybe extract a principle from that you could argue a blocking statute is justified if it prevents extravagant assertions of jurisdiction?
Well, yes. I mean, this, again, that's what Morgard says. An extravagant assertion of jurisdiction is, in a sense, improper. And so you see this coming up. There's the most recent decision in the Supreme Court of Canada is a case involving Haaretz, the newspaper in Israel, holding that a person alleging defamation in Ontario could not sue Haaretz in Ontario court.
Right.
There's a bunch of cases before that in which the court had Supreme Court had, in my view, in any case, gone rather far in permitting plaintiffs in Ontario to sue defendants outside the country or outside the province.
I see.
And so it's been around for a long. This whole problem, obviously transformed by Morgard, but been around for a very long time. There's a funny story I can mention which shows how far it can go.
Yes.
In the days of Braniff Airlines.
Oh, right.
Braniff.
Yes.
A man was flying from New York to Texas, and sitting beside somebody and having a nice chat. In those days, the pilot would announce where the plane was. He announced the plane was over Arkansas, in which case the man's neighbor pulled out a complaint, served him in the plane in the Arkansas airspace. And the question was that service effective to give jurisdiction to the Arkansas courts? And the court held, yes, it was. He was in Arkansas, in the airspace, but
fantastic.
Those are crazy cases.
Right. But this can definitely be seen then as a precursor to justifying FEMA if it's reasonable. Or
yeah, the other thing that of course, the problem again is that these statutes that have been around for a long time, and in fact, long before Helms-Burton came along, there was this the Uranium cartel.
Yes.
And that was quite a story. I remember it, and I was teaching at the time. And what happened there was that this is the early days of nuclear power, and Westinghouse manufactured reactors for generation of electric power. And Westinghouse promised the purchase of reactors a supply of uranium at a price of around $5 to $10. The story is very complicated, but in any case, the U.S. required that the uranium used be mined in U.S. sources. Major sources of uranium in the world were in Canada, I think Saskatchewan, South Africa, and Australia. And the UK was also involved. And then to boost the price of uranium, which of course was depressed if the U.S. had to buy U.S. uranium, they had formed a uranium cartel. The cartel then operated, and eventually the cartel, though people argue it wasn't the effect of the cartel, the price of uranium reached $40, and Westinghouse, which hadn't managed to lock in a supply, was then caught with uranium at the price of $40 and selling it for $10. In any case, the cartel was very secret. People were sworn to secrecy, but a bunch of environmental activists in Australia who were opposed to nuclear power got access, illegally of course, to the Mary Kathleen mine in Australia. And there they came across, rifling through the filing cabinets, about 200 pages describing the operation of the cartel. Of course, when this happened, all hell broke loose.
Oh, I can imagine.
And of course, Westinghouse then sued the people involved for triple damages under the Sherman Antitrust Act, and all kinds of things went wrong. In any case, the Canadian response was not to deny that the thing, but to introduce blocking legislation again. And this was part of the origin of FEMA.
Right. And those are through the regulations at the time,
yes,
the uranium information.
And for example, the Uranium Information Security Regulations passed in 1976 prohibited the disclosure of information to U.S. courts in the circumstances. And the Gulf case was a Gulf Oil Corporation is a top corporation in Gulf. Gulf Canada and another Gulf company were the subsidiaries, wholly owned subsidiaries. Gulf was sued in the U.S., and Gulf wanted to get letters rogatory were issued by courts in, I think, California and Washington, I think. I'm not sure in any case. And they issued letters rogatory. Gulf's an interesting case because the Evidence Act, under which letters rogatory were issued or brought to Canada, defines the Supreme Court as a court. And so Gulf brought its application directly to the Supreme Court, the court's original jurisdiction, not an appeal from anybody.
Right.
And so
we've noted that in the last bullet.
Yeah, and then the question then was before the court, given the regulations, could the subs, Gulf Canada, be prevented from providing information to in the American proceedings? Mm-hmm. And in fact, the officers, the head of the Canadian subs, were also sued, involved in it. They had their own counsel. And so the Supreme Court of Canada gave effect to the regulations and prohibited the subs from giving information. Of course, the risk of that is that Gulf then is liable because the evidence isn't there.
Yes.
In any case, the case is 1980, so predates by a long time.
Yes.
Both FEMA and even Helms-Burton, of course. So the idea of blocking statutes has been around for some time.
And Angela, just before we leave that point on the procedure, so what you're saying is, notwithstanding the unorthodoxy of coming in first instance before the Supreme Court of Canada, the court nevertheless treated it as a court of first instance and decided on the merits.
Yes, it did. Yes, it did.
Interesting.
And single judgment given by Chief Justice Laskin at the time, and he just said, this is an expression of the public policy of Canada, and we can't ignore it, and so we refuse letters rogatory.
So those regulations thwarted the letters rogatory process, essentially. Yes, interesting.
Yes. And then there's another little one, again, a funny little spat in B.C. over an Alaska ferry terminal outside Prince Rupert.
Much more recent.
Much more recent, yes, 2015. What happened there was that the state of Alaska had a 50-year lease on a site in B.C. to run a ferry service up the Alaska and the Alaska Panhandle, and they wanted to repair or renew or rebuild the terminal, and the terminal building was being financed by American governments, Alaska, I think, and the federal government, and they insisted on Buy America, and so Buy America for the steel under, what is it, I've forgotten what it's called now. I think it's Section 3.
Yes, of
Section 313.
Yes, I think it was the Section 313 of Title 23 of that code. Yeah. Yes, and I'm sorry if we don't have the name.
And so Canada objected to this. The Alaska governor at the time, I guess he was post-Palin, refused to relax it, and what happened then was that under FEMA, the Attorney General, Peter MacKay at the time, and with concurrence of Foreign Affairs, John Baird at the time, issued an order saying, with respect to that, you can see the definition there, the promises that Alaska Prince Rupert would start to comply with Section 313 of Title 23. And of course, the problem with that causes is, who's going to do that in Canada? Because if you do it in Canada, you're subject to Canadian law, and the RCMP will put a heavy hand on your shoulder, and off you go to the big house.
I see. So an actual order was issued in this case under FEMA.
Yes.
Yeah, and promulgated. It was made it was put into the Gazette, as it were, published in the Gazette.
Obviously, it was a political thing in B.C. It responded to Canadians' resentment of American Buy America rules. Not wildly clear because, of course, the project was being funded by the Americans. So, in any case, that's what happened. So, there's a long history to this. Helms-Burton does not provoke the first time that all these things have been done.
I see. And now, if I was counsel, just before we move on to the state of Alaska, could I perhaps argue that, this Buy America assertion was not an extravagant assertion of jurisdiction, given that we're underwriting the cost?
Exactly.
Yeah.
I mean, you can see the argument, the political arguments on both sides. And in any case, the state of Alaska didn't fix up the terminal, and I'm not sure how inconvenienced travelers are, but in any case, that's what happened. So
ultimately, nothing happened. Is it lose-lose for the public interest? I don't know.
Lose-lose, I think, for those who want to use the terminal.
Yes, absolutely.
Maybe can't take a full-sized ferry or something. I don't know.
Right.
And then there was you don't talk about the Honda?
Yes, we just put in there for more by way of background. There was an assertion by the Office of Foreign Assets Control in the U.S. Due to we had understood this to be Honda Canada Finance subsidiary in Canada, the Canadian subsidiary, called Honda Canada Finance. They approved and financed vehicle lease agreements with the Cuban embassy in Ottawa. And ultimately, I think this didn't go anywhere, but had the Canadian entity been requested not to lease vehicles to the Cuban officials in Canada, query whether such a request would have arisen,
Yeah, well, I think the answer
under
might
FEMA.
be that if the Americans had said don't, then Canada would have issued another blocking statute, or another, like the Alaska one, and said,
Yes.
no, you don't.
Yes.
You must lease them.
You must lease them.
You know?
So that's what...
And if that causes you problems in the U.S., well, that's too bad.
Right. Well, then those are just by way of giving our audience hopefully some context as to where these extraterritorial provisions found in FEMA come into play. And we've also included some detailed summary of the actual impact of the FEMA statutory provisions, because this will be quite important now that we're into Title III being
yes.
activated and alive. These provisions might well come into play. So you'll see one of the key provisions in FEMA that we've set out here is the prohibition on disclosure of records to a foreign tribunal that are in Canada or under the possession or control of a Canadian person. And these whole provisions on disclosure of records, Angela, seems to raise this proving a negative issue, doesn't
Yes,
it?
it's one of the problems. Yes, because if you look at at FEMA, for example, I'm not sure we have this actually on the thing, but Clause 31C of FEMA.
Yes.
So the Attorney General of Canada may, by order, prohibit or restrict the giving by a person at a time when that person is a Canadian citizen, etc., of information for the purpose. And so the problem with that is that you have to prove a negative. The Attorney General says you have provided information and they're going to, come down upon you like a ton of bricks. How do you prove a negative?
Yes.
And again, the same thing comes up with paragraph 51B. Again, the same problem. You can't prove a negative because you can't prove you didn't do it. It's hard to do that. Just a bit of background. I was a member of a Canadian Bar Association committee at the time that FEMA came in. We went to Ottawa to meet with the Department of Justice, and one of our arguments was that since you're required to prove a negative, can you give us some guidance as to what we tell our clients as to how they go about this? What record should they keep? How should they go about proving we didn't do this?
I see.
And I made the argument that the Competition Bureau, gives guidance as to when, if you are going to, do the wrong things and, say, selling differentially to buyers and so on, they say what you must do and what you mustn't do. So they give you some guidance. They flesh out the statute for these broad terms, so you know what you have to do, know the evidence.
Yes.
The Justice brushed us off as this is not their job, it's our job to tell our clients. And so there's a real problem here. I don't know what's going to come up, but clearly, because you're not. The order comes out. You have to know, what do I do to keep my client out of trouble? And
there's no guidance. We're left with these bare provisions.
We have provisions, and so each solicitor acting for the person subject to the order is going to have to figure out what evidence do I make sure my client keeps in order to satisfy the obligation that's upon it. So it's just one of these problems that
Interesting.
FEMA is a very blunt instrument.
Yes.
I don't, who knows what might happen, but I don't imagine that, they're going to come up with a ton of bricks over somebody who just, does the best they can, but it's a problem.
I see. Very much interesting. So we've also included specific provisions. Now, of course, as Angela mentioned, FEMA was enacted in 1985, long before Helms-Burton, a good 9 years before Helms-Burton, and therefore it was amended soon after that Helms-Burton was enacted in the U.S.
Amended 1996, you can see,
yes,
under 7.1.
Which directly targets Helms-Burton.
Yeah.
There it is. It's quite a clear statement in 7.1, which is any judgment given under the law of the U.S. under Helms-Burton shall not be recognized or enforceable in any manner in Canada. That's pretty unequivocal.
Yeah. And notice that does not require any order from the Attorney General.
Right.
That's just automatic.
Yes, interesting. And then, of course, then we get into the mechanics of FEMA in these provisions, including 8.1.1, which which gets triggered in the instance where a foreign tribunal has issued a judgment, I see, under Helms-Burton. And then, now, Angela, what's interesting here is that it's the AG that has to intervene to state that the order, by order I should say, that the judgment shall not be recognized. So this is not a pure private right of action, I take it.
Again, the Act, gives the Attorney General a huge amount of power, but you can see here in paragraph 8.1.1b that it may be that somebody, did do something with respect to Cuban assets which might represent a genuine claim for compensation, in which case the Attorney General has power to say, yes, you can pay part of it, but not, for example, the triple damages, the tripling of the award.
And that's the B, deemed to be reduced.
Yes.
So they have the discretion.
Yeah.
So that implies that there might be a reasonable
claim.
Well,
if you're drafting this thing up, you might say, well, perhaps there might be, who knows what might have happened, in any case, it's just there. How to be used, I have no idea.
Yes.
I can't see how, if Air Canada is sued for using Cuban airports, I don't know how there could be any aspect of B there. So.
Right, and I see. Now, so that applies to judgments in Canada effectively, as we've bolded. The next slide, which is 8.1, now accounts for the incidence of a judgment satisfied outside of Canada.
Yeah.
And in this case, it's very broad. Again, the AG of Canada can order where this judgment has been satisfied outside of Canada by order.
This is the clawback part.
This is the clawback.
This clawback part.
Yes.
And again, as I mentioned earlier, the problem is going to be to have the defendant in Canada, the original plaintiff under Title III, having any assets in Canada.
Yes.
Again, going back to the uranium thing, there was the same clawback, obviously, in the uranium thing, but I mean, if Westinghouse, for example, gets a judgment from the federal court in the U.S. against, Gulf Canada, El Dorado, and so on, then it would have assets in Canada, so that clawback might be effective in that situation.
Right.
But since if you look at the actual individual plaintiffs who now come forward under Title III, they are mostly Cubans now living in Miami. They're very often the descendants of the original Cuban person who owned the property. I think with respect to the airport, I think the owner is now dead, but his heirs are now have the claim. So clawback is, I think, very unlikely to be effective with Helms-Burton, just because the nature of the plaintiffs in the U.S. But the original clawback under the uranium mess would be much more effective, because obviously Westinghouse might well have assets in Canada.
Right. But the fact that you mentioned that the plaintiff or the plaintiff's descendants are more likely to be, say, in Florida, for example, does that mean that it's higher probability that the judgment they seek under Helms-Burton Title III would be satisfied outside of Canada?
Well, I mean, again, if let's suppose that Air Canada is sued.
Yes.
Air Canada's in the crosshairs already in various published things, and if Air Canada is sued, and I say I don't know whether Air Canada owns its aircraft, but if it does own an aircraft and is sitting on the tarmac at JFK, it can be seized, and then the question will be, can Air Canada then get back from the plaintiff in accordance with FEMA? And the answer is I don't quite know how they can do that, because obviously the Cuban, the heirs of the Cuban doctor, he was a doctor who owned the airport. I mean, they have no assets in Canada.
No, they have no assets, right.
So I think that's a real problem. I said the clawback came in with respect to the uranium mess, when of course there was a real probability that you could recover.
Yes.
Be a strong incentive on the part of the American not to seek triple damages or treble damages.
And so the last bullet we've put in this slide shows that once the AG has issued such an order, then the Canadian, in terms of the clawback, can go ahead and sue
Yes.
In Canada, of course.
Canada, yes, yes.
Yeah.
And there's no chance that judgment will be enforced in the U.S.
No.
So
again,
the
FEMA has no extraterritorial application.
Exactly.
Yes.
So this came in, the clawback is that came in with the uranium mess, and there it had some bite. And by the way, I think that all these things are replicated in legislation in the UK and in the European Union, and I imagine in Australia as well.
Very much.
We'll have there. So.
Very similar duplicate type legislation. Mm-hmm. And moving on to the next slide, just to tell our listeners in terms of the breadth and scope of FEMA, there's even a right to under 9.1 to recover. Recovery extends to prejudgment under Helms-Burton, with, of course, again, the consent of the AG in this case. So now, Angela, this is interesting. I mean, is it just more by way of a deterrent that once you get the consent of the AG, you can, or is it just to preempt, allowing someone to preempt a proceeding in respect of which judgment hasn't happened yet, but a proceeding has been commenced?
But I think that the consent of the Attorney General is common throughout FEMA, and I think it probably relates to the fact that FEMA, when it first came in, was quite brand new. I mean, it was the first of the clawback statutes.
Yes.
And so I think that if you just thought, well, we'll control it, so that the fact you've got a judgment against you in the U.S. is not going to allow you to sue up here unless the Attorney General consents. So there's a bunch of, throughout the criminal code, for example, there's a bunch of provisions in which the Attorney General has to consent. Right. It's a method of controlling litigation that one is quite sure of its scope. Because again, with the clawback, I mean, no one quite knows how far it might go, and so you have some administrative control just to make sure that it's not abused.
And we see this debate time and time again under the Competition Act, for example, when for abuse of dominance do you need leave of the tribunal, the competition tribunal, or should you just have a pure private right of action? Here, at least for now.
And it's just a way of, I don't know whether maybe Steve, you know more about how the competition tribunal uses that power. Is it easy to get leave?
Right.
Is it easy to get leave?
Yes and no. I think it's still a fencing mechanism of sorts. So absolutely. But the greater point here is that we finally have a general extraterritorial statute of general application here, as opposed to one-offs like in the uranium regs or et cetera, business records, et cetera. Okay.
But just again, just remember the regs issue in the Gulf Canada case were made under the Atomic Energy Control Act at the time.
Right.
So that's how they got that in, and FEMA then took that over and brought everything into it.
Right.
You see it coming up, the Alaska thing, and now.
So essentially into a general regime of sorts.
Yeah.
Very interesting. Then we've included in the next slide just a couple of slides from the 1992 FEMA blocking order, which was, this isn't pure Helms-Burton. I believe this was enacted, as we've said, in response to further expansive extraterritorial U.S. trade sanctions that came up through the CACR regulations in the U.S., and I think this was an order, example of an order made under FEMA to make sure that those additional sanctions, that those sanctions' extraterritorial impact were mitigated. And we've included that, an example of the impact of the order in those two slides. So now we've touched a little bit on this, but I thought we should even drill down a little, to use a mining reference, a little further on the interrelationship between Title III and FEMA in terms of real-world practical implications. And there's no question that this now non-suspensive Title III substantially increases the risk to multinational corporations operating in Canada. And Angela, you've already touched a little bit on Air Canada and Sherritt. I mean, it is difficult, isn't it, to kind of put a defined set on the entire universe of effective affected
Yeah.
Canadian companies under Title III. But it does come down, doesn't it, to those companies with material exposure both in
Well, yes.
Cuba and the U.S.? I mean,
again, as I said, if you look at that, I think that link there lists a whole bunch of corporations around the world. You know, a lot of them are on the EU, or
yes.
and some maybe Australia. I don't know, but there's about, by recollection, it's about 30 companies that are kind of listed as being exposed
Yes.
to Helms-Burton, Canada, and share of the two Canadian ones. So the problem that we have, as we made clear, is that we have this extravagant assertion of jurisdiction introduced by Title III, permitting anybody, obviously to hear Air Canada and share it, to expose them to
Yes.
international, what I think are serious risks in the U.S. I mean, Sherritt's been living with this problem for a long time. We mentioned later on, that shared executives and so on can't even go to the States, nor can their families and their children.
Under Title IV.
Title IV, so it's really quite bizarre. I mean, talk about, an extravagant assertion of jurisdiction.
Absolutely. Yes.
And again, I've got a story to tell you. We get to that.
Okay. Because I think I've seen reference to the fact that Sherritt's Cuban mine, it's a nickel mine,
Yeah.
I think they have a joint venture interest, has been deemed to be confiscated property. So,
Yeah.
oh my goodness,
Yeah.
the target there is interesting. Just for our listeners, too, I did come across, it was very interesting, that when Helms-Burton was passed in 1996, there was a WTO action commenced, but there was an agreement between the U.S. agreed, these were the good old days when the U.S. was adhering to WTO strictures,
Yes.
agreed to suspend Title III.
Yeah.
And now, of course, now that they've stopped the suspension of Title III, I wonder if we'll see a WTO action.
Well, almost certainly, I think, but again, the WTO doesn't cut much of anything.
No.
With President Trump.
Yes. Hasn't, I think, renewed the panel. I think they don't even have a quorum or something to that effect.
He wouldn't appoint the people they needed.
Right. Yes.
The other thing, just to kind of mention, Title IV, imposes restrictions on.
And we'll skip ahead to that at the last slide. Yes.
Spouses, minor children, etc. I tell you a story which gives you an idea of what the risks the Americans create. Jamie Astafan was a doctor who prescribed the drugs for what is it? The runner in Seoul. What is it?
Yes, with Ben Johnson in the 1988 Olympics.
1988 Olympics. Ben Johnson, and Jamie Astafan gave evidence at the Dublin inquiry, which was held to deal with the issue of drug addiction. And the Astafan family had assets and lived, in fact, in St. Kitts. And Jamie was flying from St. Kitts to Toronto. The St. Kitts airport is terrifying because the runway ends in a cliff. So another matter. In any case, the Americans obviously found out he was on the plane, and they ordered the Air Canada plane to land at JFK, and he was taken off the plane. So if you are somebody that the Americans want to get, you simply not only cannot go to the States, you can't even fly over American airspace because you'll be ordered to land and do it. So the American assertion of jurisdiction in these things, it is extravagant in many cases, and if they want to get you, be rather careful.
Yes, and so, I mean, I'm just struck by the broad scope of Title IV. Which even extends to spouses, minor children, or agents of such excludable persons. It's just remarkable. Yes.
So I mean, I I know Sherrod has been subject to that, and I don't know what Sherrod has done to manage the risk, but
Right.
it is a serious thing. Again, we don't know what's going to happen, because obviously the litigation has started. It is inevitable that one of the defendants will be Canadian. FEMA is there. FEMA can prevent a Canadian from participating in the proceedings, from giving evidence and so on. It obviously can't stop the American litigation.
Yes.
The judgment can't be enforced in Canada. There's a clawback. But how effective that will be, of course, is another matter altogether.
Yes.
So it's not hard. It's hard to see what the objections of Canada and the EU are to this. I can't see the World Trade or WTO gets involved. I can't see that as being effective to do this. So we have this very serious problem.
Yeah. And like every question, just popping back a slide here, I mean, it's one thing to say Canada affirms its commitment to defending the interest of Canadians, including the blocking order, but in practice, as you said, how will that play out? I mean, it's, particularly, does it get tricky if there are related entities, if there's, the Canadian, I guess Air Canada is an example, based in Canada, perhaps with a sub in the U.S., or not so much a sub, but certainly assets
in the U.S.
Assets.
I don't know whether Canada owns its planes or whether it leases them.
Yes.
What assets it have. It'll clearly have assets in some sense, perhaps, subject to garnishment or something like that even. But it's a very serious problem. And again, it has to do with, you've mentioned several times, the extravagant assertion of jurisdiction by the Americans. I can't see this being subject to a constitutional challenge in the States. I mean, the Americans have asserted jurisdiction in many cases. There's issues arising in the securities field about what's called sometimes the F-cubed thing, securities bought by in the foreign exchange by a foreign person from a foreign company. Americans try to take jurisdiction over it. The Supreme Court of the U.S. now said, no, you can't. By the way, it illustrates the general innumeracy of lawyers because they call it F-cubed, but in fact it's 3F because it's not a geometric progression, it's an arithmetic progression.
Oh, so it's 3F.
You add 1, 2, 3, you make 3 as opposed to Cuban. I've maintained for years that lawyers are generally innumerate, and so they call it F-cubed when it should be 3F. But in any case, the U.S. Supreme Court has imposed some restrictions on some of the more extravagant assertion of jurisdictions in the U.S.
Yes.
And we've seen the same thing come up here, when various actions are brought arising out of the sale of purchase of shares by somebody not on the TSX, for example, trying to bring action in Ontario, and the courts have said no.
Right.
The OSC has said no. So there are issues there.
So perhaps a U.S. court would be equally.
I don't. The trouble with Title III is that it's a statutory cause of action.
Yes.
And so hard to see how the U.S. court would do anything but say, you're stuck with it.
There's no discretion, effectively.
So I think it's a very serious problem for many people, and of course, what makes it worse is, again, unlike the uranium cartel situation, there the plaintiffs were going to be large corporations. Mm-hmm. Here they're going to be small, I call it small, instead of small individuals with individual interests. This guy said he owned the Cuban airport, the land in which it was on.
Yes.
And maybe quite likely he could have in 1958 or whatever it was, in 1960. Much more difficult to do that with. Those plaintiffs have got little incentive to hold back, and the Canadian defendant or international defendant has got all kinds of costs incurred simply in defending the action.
Yes.
And strong incentives, perhaps in those circumstances, to settle the best they can. And of course, then, not even sure then the clawback would work if it's a settlement.
Right.
Because you can't hardly argue you settled it and then you want to claw it back because it's not
a
judgment. In any case, there's a whole bunch of issues there.
So it is difficult to see how this will play out. I mean, it's difficult to give practical advice at this stage. We're so early in the piece now that Title III has been, the sleeping giant has been awoken, or whatever the expression.
Yes.
Yeah.
So, I mean, it's just, I don't know whether, it's hard to see, given before the EU and Canada have objected to it, and I can't see Americans going back on it and resuspending Title III.
No. This seems to be a definitive announcement by the Trump administration.
Yeah. And even if a new president were to come in, it's hard to see how she or he could put the genie thing back in the bag.
That's an interesting question under that hypothetical of a different administration. Mm-hmm. Would it be difficult to resist? I guess then you have all these actions that are...
Yeah, I mean, it seems to me politically very difficult to do that. I can't see a strong political will to do it, because obviously from the American point of view, who cares if foreigners are are harassed in American courts? Maybe what we have to do is act as badly as they.
Right.
Have our own extravagant jurisdictions of jurisdiction.
Yes. Maybe take a page from the recent U.S.-Canada-Mexico trade negotiations, where we slapped on our own tariffs, albeit nothing compared to Section 232 tariffs, mind you, but nevertheless, you have to sometimes fight force with force, as it were.
The large problem, of course, is that so many things work well if there is an old phrase, but kind of gentlemanly restraint. I don't like it now because, of course, it's, we have more. But just that there's an acceptance of limitations on your power. There's a willing acceptance of what you can do, and so you don't do what you can do because other values are there. And what we see with this is the rejection by the Americans of what would be expected to be ordinary limits on their power.
Yes.
I'm sorry, Cuba had a revolution. The consequences of that were that people lost their property. Get over it.
Right.
Just nothing.
You can't unscramble that
omelet. You can't unscramble the egg, or the omelet. And so,
indeed,
I don't see what's going to happen. I don't see how we can go back to the time when, I don't say that sanity prevailed, but when there was a reasonable limit, or people accepted reasonable limits on their power.
Yes. And so it goes back to norms again.
Yes, as a small country, Canada can't do a great deal, but we have to live with the elephant beside us.
Yes, indeed. And what we're left with really is, this slide we have up summarizes it, where the government statement just basically said, look, we encourage Canadian companies to familiarize yourselves with Helms-Burton, and that any Canadians with business ties to Cuba must do their diligence, including seeking legal counsel. I mean, it's a minefield of a tricky interrelationship between that legislation and and FEMA.
Well, again, I don't know what damages cruise line or Canada might be exposed to for just using the facilities. Obviously, if you acquired, because you can't acquire property in Cuba, but if you are extracting minerals from land confiscated in Cuba, I suppose the risk of liability, the amount is higher.
Yes.
But it's a real can of worms.
It really is. And I think I think we're probably going to wrap up shortly. I don't believe we have questions. We acknowledge that this is a very tricky and fairly new development in law, but we here at Aaron Burles have a regulatory practice that more frequently has implicated trade issues. So this is something we've been increasingly on our plate. So for those of you out there, please keep that in mind. But I think, Angela,
yes,
we've tried to cover the broad landscape, and we hope everyone will.
Good luck.
Good luck, and you know where to find us if you have any questions. So thank you, everyone.
Thank you.